Court of India. She actively works with NGOs in India to advocate for the restitution of internal displaced persons before government organizations. Ma'am, we are glad to have you on board. Now, beginning with our panel discussion, I humbly request Hemant Batra sir to enlighten us with his views.
Thank you, Tanishka and Nupur, for the comprehensive introduction of the topic, as well as the panelists. So let's start, because the time allocated is, I understand, about 15 to 16 minutes for each panelist. And the topic is need for judicial reforms in India. Well, fellow panelists, Ridhi and Raveena, notable office bearers of NJRC, distinguished guests, lawyers, students, ladies and gentlemen. It gives me immense pleasure in being part of this panel discussion on the need for judicial reforms in India. Let me begin with one of my favorite quotes by William O. Douglas, Judge of the Supreme Court of United States in the 20th century. He said that the search for static security in the law and elsewhere is misguided. The fact is that security can only be achieved through constant change, adapting old ideas that have outlived their usefulness to current facts. What are the current facts? If one was to talk about the Indian judiciary, well, there are about 71,000 cases pending before the Supreme Court as on August 2nd, 2022, out of which about 56,000 are civil matters and 15,000 are criminal matters. And out of these cases, nearly 11,000 are awaiting disposal for over 10 years, with 42,000 cases pending for less than 5 years, and I understand 18,000 between 5 and 10 years. Nearly 60 lakh cases, 6 million cases are pending in 25 high courts across the country as on July 29th this year. The number of backlogs in the subordinate courts is 4.3 crores, 41.3 million cases. If we were to add up the backlogs of all the courts, the number rises to whooping approximate 50 million, 5 crores. These figures are devastating. So these numbers are, I would say, a blot on the face of the rule of law and administration of justice. And quoting from an online source of Niti Aayog, which had brought about a strategy paper where it was concluded that at the then prevailing rate of disposal of cases in 2018 in our courts, it would take more than 324 years to clear the backlog. And the pendency at that time was 29 million cases that had been in the courts for more than 30 years, which numbered about 66,000 cases in 2018 December. By January 21, it had risen to more than 60%, to 1 lakh plus cases pending for more than 30 years. Now, some say it will take 30 years, some say it takes 300 years. It's a very subjective discussion because there is no scientific formula. But we must acknowledge with all honesty, candidness, and magnanimity that there is a problem somewhere. We won't become small by this sincere confession. And before suggesting the kinds of reforms required in the Indian judiciary, let me first compliment the Indian judiciary with all genuineness. Our system of governance is based on the separation of powers. We all know, with the concept of checks and balances. Legislature makes laws and public policies, whereas executive enforces it. And both these organs have enormous powers. and wide domain of public dealings and administration. All these powers and mandates make them vulnerable and susceptible to excesses, or if I may say, unrestrained exercise of authority, whether knowingly or unknowingly. Judiciary in India has played a significant role since India's independence as a custodian of the Constitution of India and the rule of law. They have constantly checked and balanced the other organs of governance. The judiciary has overwhelmingly prevented excesses and breaches of the fundamental rights and laws. Having said that, somewhere I feel that judiciary did not reform itself as much as was the need of the time and society. The judiciary should realize that it cannot survive in vacuum. It must change and recast itself so as to meet the changing needs of the time, changing norms and values of the society. Lack of reforms stifle growth because separation of powers in India is not a model of watertight chambers. Lack of reforms in one organ of governance causes collateral damage and dampens overall development of a nation. That realization has to come. Let me now quickly touch upon the kinds of reforms which can be rapidly introduced in the judicial dispensation, according to me. First and foremost is a reform which has also been very effectively suggested and mooted by the ex-Chief Justice of India, Honorable Justice N.V. Ramanna, retired. That reform is about introducing an effective system of alternative dispute resolution. I'm not talking about arbitration here, believe me, and nor was he. I'm talking about conciliatory mediation. Now, before filing any dispute or case in court of law, tribunal, one must mandatorily, compulsorily make a professional and legitimate and authentic endeavor to resolve the conflict or dispute amicably by mediation. In many developed countries of the world, the lawyer who files the case must also sign a declaration with the case as a prerequisite that he or she had made all possible efforts to resolve and settle the said dispute before filing the case. And the lawyer can be reprimanded if the declaration is found to be false or misleading. Plea bargaining will need to be popularized in India and encouraged. In a way, it should be incentivized. It is not as popular as it is in the developed nations of the world. In Canada, for instance, it appears that about 90% of criminal cases in Canada are resolved through the acceptance of guilty pleas. Many of these pleas are direct outcome of successful plea negotiations between the Crown and Defence Council. UK, I understand, is 70% to 80%. Australia is about 80 to 85%. The conviction rate via plea bargaining in the United States of America is as high as nearly 90%. Ridhi will correct me on this because she's studying there now. It is not even, and India is not even close to 10%. Second reform is about usage of technology, I feel. And this reform has also been strongly propagated by the future Chief Justice, D.Y. Chandrachud, Justice, one of the senior most judges in the Indian Supreme Court. Introducing technology in dispensation of justice system is also a rapid reform, I feel. There are many reforms which I can think of, but I want to first, discuss the ones which can be executed, implemented rapidly or swiftly. If I was to tell you about that let us invest hugely in the judicial civic infrastructure, like having more and more courts and buildings and chambers and that would mean years to go by and go around. As Victor Hugo, the French poet and novelist, beg your pardon, is credited with the phrase, "Nothing is more powerful than an idea whose time has come." That holds very apt true in today's time for technology and the artificial intelligence. It is unstoppable now, and there is nothing wrong in it. Artificial intelligence is born out of natural intelligence. It is born out of human intelligence. Why can't petty disputes and issues like traffic violations or cases of small consumer disputes, refunds from service providers, be settled by AI, by artificial intelligence? You put in the details in the automated form and matter gets instantly resolved. If our income tax returns can get scrutinized by a software and artificial intelligence, which is financially complicated phenomenon, then why not introduce something similar in some segments of judicial dispensation? Why not? I would not like to, touch the debate on faceless adjudication, because that is something which will take time and can be kept for some other day's discussion. Globally, many companies have turned to using online dispute resolution, which is known as in short form ODR or e-mediation, as a method of dispute resolution. For instance, eBay, PayPal, and ICANN are the front runners in ODR. eBay's ODR system is unbelievable. It's a high volume ODR process that addresses disputes from a systems perspective. eBay handles over 60 million disputes, 6 crore disputes in a year. eBay's ODR system handles problems like items not received, or let's say unpaid item, and so on. Now, reducing the paperwork and digitizing the court proceedings, eliminating human registry interventions as much as possible is also a reform which is much required. Introducing video conferencing in every aspect of court proceedings, recording of evidence, including witness examination, cross-examinations, and so on and so forth. We can go on and on to take help of technology. Believe me, related to technology only is the point and reform regarding online and virtual hearings, I feel. The world is shrinking as the borders fade away. We have entered a technological revolution phase where you are only talking about intangible wealth. It's a global phenomenon, according to me. We all have come, so close to one another through medium of virtuality. I'm addressing an event here, sitting in my home office. Can you believe it? That is productivity and efficiency and convenience. And that too on a Sunday. Then, I also think about conventional reforms, but with some innovative thinking. I mean, we need a big number of new judges to be appointed to deal with humongous load of pending cases. Why not engage judges on contractual terms for a particular duration? I mean, they could be law professors, they could be senior lawyers, they could be retired judges, etc. They could be competent lawyers like Ridhi and Raveena, and their courtrooms will be their desktops and laptops. They should hold virtual courts from their respective homes or workplaces. Another reform, which comes to my mind is about training of judges. Rather, I would say coaching of judges by the academicians and law teachers, and even research law students. About précis writing, we have completely forgotten the significance of précis. I mean, in my school days, Pressy writing was a big thing. Summary writing, an exercise of compression, you know, har cheez ka nichod. Now, judgment should be written like a gist. Why do judgments lay out a whole chronology of facts and circumstances and arguments? Why? These should be mere annexures or exhibits to the judgment. You don't have to reproduce all these. I mean, judgment should be brief, 2 to 3 page verdict, and rest could be annexures like written submissions, etc. Why do we need a lawyer to explain the judgment to a litigant? Why? Now, and to the disputing parties. I mean, it should be easily understandable by the parties. We don't need Shakespearean English in judgments. You know, I mean, we know judges are brilliant. They are analytical. They are judicious mind. They are judicious minds. That is why they are judges. I mean, they don't need to demonstrate and prove their competence and proficiency by passing and writing detailed judgments with Shakespearean English. I mean, we all need to trust judges, even if the orders are not squarely thorough speaking orders, I feel. I mean, this is an important reform in my view. There are several other reforms like, you know, decriminalization of regulatory offenses, more like compounding, you know. But I think as time is short, we will keep other reforms for some other time. I will, you know, like to close my address now with a quote by one lesser known philosopher who said that the worst part of judicial system is, instead of fighting against injustice, people are fighting for justice. That's a sad part. Thank you, everybody. You know, I really spoke like a Shatabdi Express because I thought I'd try to cover all my points in this window. But I'm really interested in hearing Ridhi and Raveena's views, and followed by, you know, any Q&A. Thank you so much. God bless all of you.
Thank you so much, sir. And Indian judiciary has actually reformed a lot in the last few years, but still there are a lot of, there is a huge potential with respect to all the points that you have mentioned. Thank you so much, sir. Now I request Raveena ma'am to present her views on the motion.
Hi everyone. Firstly, thank you Tanishka and Nupur for the lovely introductions, and it's really a pleasure to share the panel with Hemant sir and Ridhi. I'm not doing very well, so I may not be able to speak for a total of 15 minutes. So please excuse me if my address is shorter. I think Hemant sir has covered pretty much what is, generally what comes to mind when you think of judicial reform. And I think to begin with, when the topic came to me, I first thought of thinking about what really is the judiciary doing in India and why do we have this level of pendency of cases? Because at the end of the day, when any Chief Justice retires, we get a report card. This person was able to solve so many pending cases, this person did that, etc. And I came in contact with a lot of people who are trying to appear for the judiciary, and some district judges, some people who were part of the judiciary and then decided to quit and get into private practice. And these interactions showed me that these judges who come at a district level, unfortunately, and I think Hemant sir touched upon that, is that they really lack training. They give these exams, they study these academic subjects, and they come in without knowing how to deal with a matter, how do you write a judgment, and how do you really dispensate it? How do you make sure that the end person, because if you're a district judge, you're, the person who's come before you, the litigant, he may not be a very well educated person. He may be someone who is in a village, or she may be someone who comes to work in different homes, or they may be someone who are still not being able to get a proper sense of what the law is or what education is. So the judgment needs to be very, very basic, very to the point, precise, and that's something that actually delivers justice rather than protects the judge. That's very important. The other thing that I felt was really lacking is that I think between the higher judiciary and lower judiciary, there is a huge gap, because judges in the districts, they're not even able to sometimes understand the purport of a judgment that's coming from a higher court. Since we live in a common law system, when a higher judiciary gives a judgment on the same topic, then the lower judge is kind of bound by it. However, if the lower judiciary judges don't understand the implication of those judgments, or sometimes they see that there is, differences between judgments of different benches, they don't know how to apply it, which leads to a greater sense of pendency. So, and they kind of want to just leave the question open, or they misinterpret the law several times just in the hope of not offending a senior judge rather than doing the right and logical thing to do. So in that light, I think it's very important that the higher judiciary, as sir said, judgments should be concise, but if you can't do that, then you yourself, like how we used to have a Supreme Court SCR, Supreme Court reporter earlier, which doesn't exist anymore, they should start with their own head notes before every judgment. I think that would give everyone a lot of clarity in a very IRAC format on what is the issue, what is their key holding, because that makes it easier not just for the end litigant, but also someone lower down the ladder to understand how to approach the answer to a subject. Writing is another thing, but first you need to know what is right or wrong and why has someone come to that analysis or reasoning. So I think that would go a long way into addressing these concerns. When it comes to training, I think we already have a system in the Supreme Court, for example, where Supreme Court judges have law clerks that they appoint. And these law clerks are, people who've just graduated from law school or with 1 year of work ex or 2 years of work ex, who come and they help judges with research notes, etc. In my view, I think instead of having law clerks or supplementary to it, there should be a similar training system where you get district judges to come sit with Supreme Court judges and learn and see how do they write judgments, how do they think, how do they ask questions, how do court proceedings go. And I think once a few of them learn and go back, they can go ahead and train the rest of the judiciary at their district levels. And I think that would make a sea change, because that change would come from them after learning from people at the top and where they aspire to be. So I think that would really make a world of difference when we look at, how things can change from the ground level. Apart from that, I do think it's commendable that in the last few days, especially the last 15 days, we've seen a huge dip in the number of pending cases. And that's because we can take inspiration from, the current CJI's regime, where he is trying to make small changes that are going a very, very long way in ensuring that pendency drops. For instance, there are matters which are just filed where defects are not cured, and they have now been removed from the register if they are a certain number of years old. Because oftentimes what happens is that for the sake of pleasing a client, a lawyer will, file an appeal instead of giving that client advice that this appeal will not be successful. And even the courts, oftentimes, they would allow notice in most of these matters just because they are the last court of hearing and the last, option for the litigant. But there are so many pending and paperwork issues. In the meantime, people realize it's not that big a deal. They don't pursue it themselves, etc. And the matter really loses strength. So I think instead of filing something, it's very important for litigants and lawyers to sit back and think about the merits of that matter. Can it be resolved in some other way? Can it not? Like, for instance, ODR, I thought was a phenomenal suggestion, right? Even before filing anything to begin with, consider ODR. ODR should also be considered at an appeal stage, that even after you don't have an initial order in your favor, you should have the option of going ahead and settling in court. Commercial settlements also flows from that angle, like how plea bargaining is something that's common in the West for criminal matters. In the West, we also have settlements of commercial cases where they just come to regulators or to courts. They say, okay, we will settle this. Whatever you have a problem with, we will not do it. We will pay a fine and let's move on. Because entering into litigation and defending oneself again and again for the sake of reputation is actually a waste of judicial time and effort. And companies also, like in criminal matters, companies also need to be encouraged to come forward. So this itself reduces the number of matters being filed or pending, at that very inceptive level. I think apart from that, something that I thought would be a big change, and I think it's always under debate, is having, a unified judicial appointment system. Currently, all of our junior district judges are appointed with respect to different state commissions, and it's a very regional process of appointment. Even the law minister has recently expressed that it is important to consider all India system, which really tries to make sure that we have a more centralized system. We know how many judges are available, how many are in which state. They can be easily moved from state to state if required. And you don't really need judicial intervention at that point to deal with pendency when you have systematic implementation in place as well. So I thought that is something worth rekindling and considering for people who are, in authority and decision making powers. And this is a good forum to raise it because you girls are doing phenomenally well, and hopefully it will reach the right ears. Apart from that, because this is a topic where we are trying to understand this issue from a more women-centric perspective, I thought one suggestion that Sir also gave is that adopting virtual courts more wholeheartedly and virtual proceedings more openly would really be an impetus for women to join the judiciary and do service to the country in the form of the judiciary. There are studies that say that in 2020, not more than 10% of judges across high courts were women. I think those figures would have marginally changed in the last 2 years. But it is very important to encourage women, encourage people from marginalized communities and different stratas of society to come forward and take on these public roles, to ensure that there is not just representation from their end, but that they are able to do service to the public in a manner without having to compromise on other aspects. Women are not generally keen to take up positions of judiciary because there are issues with respect to timing, payment, transfers, etc. But if these issues are resolved at a more higher up level, and it becomes a more incentivized program for them, I think we would be able to see a greater number of women in the judiciary and coming forward. Just take an example. If a court is virtual, if there's a woman who has a couple of children, she can make sure her children are sent off to school, do her household chores, and simply log in. She can read her papers while her children are not available in the house and follow up on her work. If she has the assistance of one or two administrative staff, they can help her in terms of research and trying to help her in terms of formulating even a structure of a judgment, which then she can work on. So there are many different processes in which we can do this, but I think support from the system is of primary importance if we want more women to be represented, and not just women but members of all other social and marginalized communities to be represented in the judiciary. I think that is very, very important. And I think apart from that, I thought that cases that are, for example, um, matrimonial or which are not constitutional interpretation related cases, simple appeals from say IT matters or other run of the mill matters, I think we should consider a more large level reform where these matters are taken up by a different appellate authority, and the burden from the Supreme Court, which is supposed to be a constitutional court, is really reduced. The entire time goes in hearing all of these other cases, which don't really require a Supreme Court of a country to sit and consider. If we see other countries, they don't do the same thing. But India is different because we have a people's judiciary. They try to listen to as much as possible, admit as much as possible, because they are the last resort for everyone in the country to be able to get justice. But if we had a body which was separate from this to be able to hear these run of the mill commercial matters or run of the mill matrimonial and other matters which don't require constitutional deliberation, then it would not just reduce pendency but give opportunity to more individuals to even join the judiciary in these ranks and deliberate and discuss and arrive at answers for these issues. I won't go on further, but thank you so much for your time and thank you for bearing with me. And I will hand it over back to Nupur and Tanishka.
For sure, ma'am. We hope you get well soon. And as you highlighted, a very crucial point of training, right from examination point to the ability of judges and lawyers of interpreting the matters, and shared the ways in which we can address the state concerns. We are extremely thankful to you. And with this, we request Ridhi ma'am to provide her views on the same.
Hi, everyone. At the very outset, I echo Raveena's ailments and concerns because I'm also not doing well at the moment. I'm suffering from a sore throat. So my address might also be a little short, but I do hope to build on what Hemant sir and Raveena have very succinctly highlighted as the crucial ailment that currently plagues the Indian judiciary and why the need for judicial reforms has arisen in the first place. Thank you, Tanishka and Rupur, for the lovely introduction and for the amazing work that you guys are doing with the WICCI and NGRC. Just to sort of build on what my esteemed panelists have laid out before me, the pendency of cases and the tremendous backlog that the Indian judiciary is currently plagued with has served as the key and crucial component of why we need judicial reforms in the first place, right? And what the crux of our discussions and our sort of arguments have been is how do we reduce the pendency of these cases? What are some of the ways that we can look towards reducing these pendency, be that an increase in case management and administration abilities, increase in increase in judge capacity, increase in the number of judges that are appointed. But the crux still remains the same, that India is currently plagued with a tremendous backlog of cases. What I would like to start off with is by saying that I think what the COVID-19 pandemic inadvertently, and in our case, fortunately, ended up doing was an increased reliance on technology, which was rendered crucial for the shift from physical courts to virtual courts. Technology in and of itself is value neutral. It its ability to enhance and oppress rights, in the present case, that for the common man or woman in India, is contingent upon its close monitoring and sort of regulation by government and non-state actors. So, luckily for us, till now, for the past 2 years, that has been done in a conscious manner, and digital mediation by Indian judiciary has seen a lot of advantages, be that in terms of movement towards e-courts, increased reliance on artificial intelligence for case repositories, case management, administration of justice. COVID pandemic only amplified the need that that it presently exists to strengthen our digital capabilities, and it only provided an opportunity for change to everyone. So Indian courts are definitely not an exception, and definitely not Supreme Court of India. I also want to preface this sort of increased reliance on technology by highlighting some of the valuable additions that the third phase vision document introduced by the Supreme Court E-Committee has sought to achieve, which is in principle is the creation of a digital infrastructure, be that the strengthening of the existing infrastructure in digital courts, introduction of a positive change in digital courts in high courts, and also the increased capacity for case management through digital means. So some of the valuable benefits that I have seen from the vision document that are starting to be implemented practically are digitization of existing case records. I feel like the shift that needs to happen from physical databases or repository of cases in these bulky case rooms to a virtual database is a tremendous change, and it essentially increases access of public, makes it available to public, the case repositories in a virtual database, which I feel like is a tremendous valuable point. Also, I feel like an increased reliance on AI definitely reduces the carbon footprint. Government of India is the biggest litigant in our country, and these bulky file and case records that were at least being filed and are still being filed in Supreme Court. High Court has instituted on only e-filing system. So that tremendous load of carbon footprint is an amazing change. I personally feel like. Also, I believe this has not been fully introduced yet, but is in the works, but might make for a valuable addition in decreasing caseload, is the introduction and increased use of artificial intelligence for judicial management and administration. So be that at least from and that will follow the entire track cycle of a case, be it from the institution, and that will follow it to the disposal of that case. So right from when a case enters into the judicial system from the registry, So the automatic listing of cases and artificial intelligence tool could definitely help in that. There is, as the current CGI has also highlighted, there is a lack of clarity and transparency in how cases are listed in the Apex code, especially urgent cases. So I feel like an automatic tool or an automatic app would definitely aid in that. AI can also certainly help in predictive analysis of cases. So that might reduce the initial point of judicial pendency, that is institution of cases. And you can have an app which tells you what your chances of success or failure in the case are. It's being very successfully implemented in many countries, France, for instance, and can certainly is being suggested by the next CGI designate, Justice DY Chandrachud, and should definitely be in the works because I feel like it might be a very valuable tool in reducing the pendency of cases. Uh, Secondly, the NJDG, National Judicial Data Grid, I feel like is a very valuable tool in analyzing the pendency of cases, but also efforts are being made to sort of digitize that and make it more accessible to public. And that definitely is a reform in the right way. So these are some of the advantages of digital mediation that have come about in the last 2 years that are uh, that have been laid stress on in the 2021 document that was introduced by the Supreme Court C committee, that will tremendously help, I believe, the backlog of cases. Secondly, a second aspect of also judicial delay and backlog of cases and the whole concept of justice delayed and justice denied, at least from the apex court, is that India is placed in a very peculiar position. I believe in a great position, but in a position distinct from its counterparts in foreign jurisdictions in far as the role that the Supreme Court has in effecting an administration of justice. Supreme Court has several jurisdictions and carries out advisory jurisdiction, appellate jurisdiction, original jurisdiction. During my time here in the United States, I've come to very closely analyze the jurisdiction that the United States Supreme Court exercises, and it's not, the federal constitution bars it from exercising advisory jurisdiction. And as all of us are very clearly aware of, that this is one, the suo motu power of advising by the Supreme Court of India is one that it exercises frequently and very judiciously. So while that is great, I feel like as a constitutional court at its very core, the Supreme Court of India is also beholden to exercise that jurisdiction duly, and that can be exercised, and a sort of intent in that direction is being seen from the current Honorable Chief Justice of India, with the idea of the very welcome idea, a recent idea of an institution of at least one constitution bench in Supreme Court throughout the year, which I believe is a sweeping change if implemented effectively, and can really curb a lot of constitutional law pendency of cases that have been pending for innumerable years or even decades for some cases, and that which pertain to a citizen's fundamental human right, or a fundamental right to life or education, or just, rights like that. So the core idea is that a common man or woman's faith in the judiciary, or at least in this case, the highest court of our land, should not be shaken, or should definitely not be eroded. So there should be an increased transparency in how cases are listed, in how cases are disposed of from the institution to the disposal. So I feel like, again, coming back to my first point of increased reliance and dependence on technology will go a long way in helping us ensure that, but also how the technology is used, what applications are being employed by the Supreme Court, will set a stepping stone to the lower judiciary as well, to the high courts of the states as well. So that we have to be very wary of and be very careful of, that it's not misused and utilized in the wrong way. But the current trends are hopeful and are going in the right way. Definitely with the introduction of paperless chambers, There an application, I believe, if SCI Interact, that has been introduced for only the judges of the Supreme Court, that allow them to have all papers and files of the case in a virtual way, and to have it online, and they can they can make case notes side by side, and that's shared with their law clerks as well, is again a great idea to like sort of implement the e-courts project in its whole spirit. So these, I believe, the introduction of a constitutional bench, if we can't have a constitutional court specifically designated to questions of interpretation arising from the Constitution, then that, and the increased reliance and judicious use of technology by the Supreme Court of India, I feel like these will serve as good starting points for judicial reforms in India.
Exactly, ma'am. The use of artificial intelligence in virtual databases, if included in the system effectively, could help to be more efficient. Thank you so much, ma'am. This has been very insightful. And now, furthering the discussion, we aim to keep this discussion panel as interactive as possible. So, for this purpose, we'll begin with a series of questions for all of our panelists collectively. And we take this moment to thank all of the registered participants for providing us these questions and concerns. And this round is more concerned towards the working and structure of the Indian judiciary. So we have sorted from all the questions, and we'll try to address as many as possible during this panel.
So the floor would be open for all the audience to ask any follow-up questions or queries or concern, either from one of the panelists or any all the three of them at the end of the discussion.
So the first question, panelist, is that Richard Susskind in his seminal work asks the questions that is courtroom a place or a service? So how do we look at the introduction of these virtual courts in the light of the question that Susskind possesses? And sir and ma'am, are we moving towards the technocratization of judiciary?
What is the letter part you mentioned after Richard Susskind's observation? What else did you say?
So how do we look at the introduction of the virtual courts in the light of the question that he has possessed? And also, are we really moving towards the technocratization of judiciary?
Well, see, Richard Susskind, as you know, way back in 1991, had predicted that technology would comprehensively, phenomenally, and irreversibly change the whole spectrum of law practice. And not only law practice, which takes place in the chambers of the lawyers or in the courtrooms, even how the non-lawyers deal with their legal affairs, which means the clients. Now, the technology has already changed the whole approach towards law practice, and that is why we have taken a big leap towards hearings of the court being displayed even on YouTube channels today. Because I was looking at some YouTube videos, and I could see that there are several high court hearings which have been uploaded on YouTube channels. So this definitely has brought about a lot of transparency, and the courts are still looked at as the premise of lords, but the whole approach is fast changing, and from the untouchability of the dispensation, it is moving towards the domain of service. And people, the newer generation legal fraternity, is definitely looking at courtrooms as service providing platforms rather than administration of justice. Because as they say, that justice should not only be done, but it should be seen to be done, and which in a way means transparency and openness, which is coming with technology. And as Richard Susskind had predicted, things are coming sort of to the surface now, that judges are no more sons of lords. They are actually servants of the litigants.
Raveena ma'am and Ridhi ma'am, your views on the same.
I think I agree largely with what Hemant sir has said, but I do think that the digitization of the judiciary, while it makes it a service in the way that it makes it more accessible, the role still remains dispensation of justice and administrative. So, just clarifying on that, I think it's very positive the way that we're moving towards embracing technology. And while technology cannot be the only way out because internet is not reachable in every corner of this country, it does to a great extent help bring out about transparency, accessibility, and ensuring that there is a platform for people on both sides, right? Those who want to join the judiciary but have physical constraints in terms of being able to go to a physical office and dispensate duties, as well as litigants and lawyers who may want to have greater flexibility in terms of how they appear for their client, right? So I think this is becoming a really big welcome change, and we are embracing it as time goes. And I think a hybrid model should be here to stay. I think that would lead to great changes and great progress as we go along.
No, I wholeheartedly echo all the points that have been laid out by Raveena and Hemant sir. Digital mediation is great, to be honest. We're at least this generation is a generation that has seen the advent of technology, is very familiarized with the smartphone. So, uh, I mean, it's a natural part of the process that the reliance on technology for everything will increase, and courts are not an exception to that. But as I again highlighted in my introductory address, reliance on technology is essential, at least in these times, but it should be sidestepped with a note of caution. Um, at least in a country like India, where 70 to 80% of our population resides in rural areas where internet connectivity and internet connection is very remote, and internet has not penetrated, as as one of the participants in our chat very rightly pointed out in the chat box with a question that internet has not been able to penetrate in the interior parts of the country, and what do we do there? Uh, Even the committee's report and this vision document that in principle seeks to enhance the existing judicial infrastructure is silent on that. I mean, it has sort of come up with these e-seva kendra. Uh, there are these, urbanic versions of cyber cafes with desktops being set up, and not every lawyer is privileged enough to have a laptop or to have a viable internet connectivity, a problem that we definitely saw happening quite a lot in virtual hearings in Supreme Court, in high courts of the country, in district courts, with a lot of district courts actually operating during the pandemic on WhatsApp video calling, because that was the all pervasive technology that was available to so many citizens of our country and to judges alike. So digital mediation can go a long way, but again has to be met with sort of supporting infrastructure. So I feel like that sort of sums up my view on this question.
Thank you,
you,
ma'am,
sir.
and thank you all the panel members. Um, the second question that has been given by the registered applicants is that we all are aware that the rape laws in India underwent a radical transition after the J.S. Verma committee report. So, do you think that the reforms brought ended up making a difference? According to you, have been the shortcomings of these reforms, if any, and what is the future course that you envisage, ma'am and sir?
I think I'll let Raveena and Ridhi first address this, because I'm not very well versed with. I know, I mean, the Justice Verma committee had sort of suggested several reforms, and how they have been implemented in letter and spirit. I think perhaps Ridhi and Raveena, I mean, if they would have some sense about it, they can throw light on
I
it.
think generally the criminal reforms that we have now with respect to women, they criminalize a larger number of bodily violations against women, which I think is a very welcome step. Even something like stalking, for example, um, can be criminalized. Even non-penetrative intercourse is something that can come under the radar for other violations as well. So I think we've made a very strong step further, but having the letter of the law merely in a document is not enough, and implementation of this is of high importance. We've come some way from having a two-finger test for a woman to prove whether or not she's been raped, but we still need to go a further way to find out how we can encourage people who are victims of these heinous crimes to come forward, and how more than judiciary or lawyers, police authorities, who are the actual people involved in most of these cases, to bring it to justice, can really help the victim while being objective in terms of evidence collection, make sure that no evidence is swept under the rug, and present an independent case, for it to be taken forward. So I think more than having a letter of the law, it is these things on the ground that we need to do through policy initiatives more than anything else, and training on the ground level to bring greater reform for criminal violations vis-a-vis women.
Right. I will only seek to add to what Raveena has rightly pointed out. I believe it's crucial to sort of go one step back from the institution of the J.S. Verma committee and the 2013 Criminal Law Amendment Bill as we now come to see it. The Criminal Law Amendment Bill 2012, which recognized the long-standing need for reform in rape laws, be that enlargement of the very definition of rape, enhanced evidentiary rules in taking witness statements, and the procedure surrounding rape laws, the increased category of aggravated rape, as well as introducing newer offenses under the broader umbrella of sexual assault, had been introduced in the parliament in the first week of December 2012. Once the unfortunate Delhi gang rape incident happened on 16th December, the J.S. Verma committee was constituted in the later half of December 2012 to review this bill and sort of introduce more changes because the entire country was in furor, and that momentum had to be sort of utilized. Now, the JS Verma committee, made several recommendations on some crucial loopholes in rape laws, which I believe is not common knowledge, but were unfortunately left untouched by the actual amendments. These were criminalization of marital rape, change in the very paternalistic language of the law that we see surrounding rape laws. We still use outraging the modesty of a woman, and for some reason cannot go to the core of the concept, that is sexual assault. The J.S. Verma committee also introduced a change of wanting to reduce the age of consent for below 18, and they wanted it to be 16. However, these changes were not introduced. On the contrary, changes and recommendations that were not suggested were sort of implicitly taken away from the committee. There is the need for capital punishment, which the Justice Verma committee did not suggest, but saw its way creeping into the act, to the rape laws. So there have been several advantages of the reform. I feel like as a student of law, I have only studied the criminal procedure and Indian Penal Code after the reforms came in about. But I was a student of law in 2012 and 2013, and from a student to a practitioner now, I can verifiably say that there have been a lot of advantages of the reforms, be that from the very expansion of rape to include penetration other than vaginal penetration. The law now captures a whole wide range of sexual violence and forms of sexual assault that was happening earlier but could not be penalized. This is specific inclusion of rape by armed forces, addition of crimes like voyeurism. Acid attacks have found a place in sexual assault and violence cases. Given our country's checkered history with caste-related violence, disturbing a woman in public has also been included as a crime. It's a welcome change. Given from a large vantage point, the access of a common woman to the criminal procedure and the criminal judicial system has increased post reforms, I believe. That can very well be from the mandate of compulsory FIR registering, which has enlarged access, and can very clearly be ascertained from the post 2013 statistics of the number of women that are coming forth and reporting rape cases. So that can be supported by a change in criminal procedure as well. No change in substantive law is complete without a commensurate change in criminal procedure, and that has also happened with these reforms. How a woman's statement is taken, how a survivor, I don't like to use the word victim, how a rape survivor's compensation is then adjudicated. All of these criminal reforms have also really been for the better. On the large, I believe the reforms have started, and definitely the Delhi gang rape case started a conversation surrounding responsible sexual behavior. I mean, no legislation sanction, as cliched as it sounds, no legislation in and of itself can reform an entire country's view surrounding any law. So, and rape and sexual violence is not an exclusion to that. The real reform doesn't come from a legislation; it comes from the people. Only when the narrative surrounding rape, the stereotypical notions surrounding rape laws, and how a woman's testimony needs to be corroborated by independent witnesses, by a medical practitioner, how these sort of loopholes and these sad evidentiary rules are hindering the access of rape laws. And in India, that conversation and that narrative, a shift in that narrative, will eventually go a long way in effectively implementing the principle and the uh, idea behind the J.S. Verma committee. In its final chapter, the report had recommended various ways in how these societal constructs and mindsets about sexual autonomy. It was a broader discussion on how gender and sexual autonomy and how this male construct surrounding it needs to be changed, and how there needs to be a conversation around sex education in schools and conversations around responsible sexual behavior. And these were ideally long-term goals. This cannot happen in a matter of like 5 to 10 years. But the conversation has started, and that's a hopeful step in the right direction.
And one little thing, I would like to add what, picking up from where Raveena left, that, no matter how many sets of public policies or legislation you may introduce and you may have with the benefit of thought leaders, if they are not implemented and enforced in a way that they were intended to be, then they are, then their fate is basically a trash basket. And I have been reading that in rape cases, different high courts have taken a completely divergent views with regard to settlement of cases between the survivor and the accused. And in some cases, the accused has actually married the survivor, and the matters have been resolved. Now, I'm told that Supreme Court is going to lay down, a law of finality, because some courts have said that, no way you could settle these matters, because this is an offense against the state, against the society at large. So these are not private sort of disputes. So that is one area I think where the judiciary will need to be, will need to sort of throw some light as to clarity, because there is lack of clarity. And I've been also asked these questions randomly at some forums, with regard to that, in India, criminal matters get resolved by virtue of settlement between the victim/survivor and the accused. But at least it shouldn't be in the rape cases, more so when CRPC says that there cannot be any plea bargain with regard to offenses against children and women. So I don't know how high courts are in exercise of their constitutional powers, going ahead and sort of throwing out of the window these matters. Thank you.
Thank you, panelists, for your thought-provoking and enlightening views on such a needed topic. So, with this, we are opening the floor to the audience. We'll be taking up questions from from them, and we'll request the panelists to feel free in clarifying any query or doubt that they may have.
So in chat box, the very first question is for Hemant sir. So, how can the appointment and training process of contractual judges take place, and what about their position and rank in the judiciary?
Well, see, I mean, as we have seen transition from judicial process to the ADR process, which is getting a lot of support from the highest court also now. You know, you go to Supreme Court, the first endeavor of the judges of the bench is that this matter can actually be resolved outside court. So why don't you guys sit with the help of your lawyers? Or sometimes they say, okay, not with the help of your lawyers, let us appoint some mediator or a conciliator. And sometimes they say, okay, let us appoint an arbitrator. So there is an insistence, which is turning into persistence now in some high courts. When we are seeing that part, I don't think there should be any challenge with regard to appointment of contractual judges. Judges, even in high court, we are having additional judges who are confirmed after a span of a year or two. There are judges who are on probation. So likewise, following that principle, it is not difficult at all to have some experts of particular industry to take over as judges. I mean, you could call them, instead of judges, arbitrators or conciliators or mediators, and give them a little more sort of power as to be able to impose their decision on both the parties. So I mean, so any expression can be coined if the existing set of judges or judiciary feels slightly insecure, then they can always give some other name or tag to those appointees. And these contractual people could be appointed from the stream of academicians, from senior lawyers, from retired bureaucrats, to even young lawyers. Why not? Because at the end of the day, there are diverse there is so much of diversity in terms of disputes which come before judges, and many a times judges express their anguish and agony as well, as to that these are such petty matters, they are just eating away their qualitative time. So these matters can actually be outsourced to these contractual appointees, who could be compensated not on the basis of not doing any work, on per hearing basis, or let's say per disposal basis, not even hearing basis. Because even mediators, if you go to any mediation center in high courts, almost all high courts today have mediation centers. There, the lawyers who act as mediators are paid on the basis of success, not on the basis of hearings. You know, if they meet success, then they get compensated, else they get very symbolic amount. So likewise, these appointees can be given some sort of incentive for disposing of the matters, and they can make first endeavor to resolve it by virtue of conciliation. And if that is not possible, then they can actually give a verdict, which could be subject to appeal. So, and with regard to training, that's not difficult, because we have several judicial academies now which are operating. There is one in Bhopal which is doing phenomenally well, where even high court judges go for training. So there is no dearth of judicial training institutes, and there are also some talks and lectures and workshops and seminars which are done regularly by some courts, some high courts, not very regularly. Perhaps that's the area which I have been even mooting, and I've spoken to several sitting judges also, that they should try to get some retired judges to address these talks, seminars, workshops, and even some foreign judges to come and share their experience, because it's very important for our sitting judges to get updated about the changing spectrum of law, dispensation of justice, and so on and so forth, because they're so busy with hearings and then writing the judgments. They are increasingly becoming frogs in the well. They have hardly any sort of inclination as to how the outside world looks today. What is the sense of aspiration, expectation from the people on the streets, or even from the young generation lawyers? And many times when I engage in discussion with judges at different forums, I get to know that they have become very isolated because of the general notion that judges should not be social. They should not tend to meet people, because if they tend to meet people, they will come under criticism. People will start accusing them of perhaps favoritism and so on and so forth. So they have become so cautious and conscious about their meeting people, and which is actually disabling their learning faculties. Because dispensation of justice is not only about reading the briefs and giving a judgment. It's about psychology. It's about orientation. It's about the whole thought process. It's about the chorus of the society, community put together.
Thank you so much, sir, for pointing out such things. And with this, we are moving ahead to our second question. So one of our attendee has just put up a very interesting question for our esteemed panelists, that what are your views for having a central examination like UPSC for judiciary?
I'll leave it to the other co-panelists because I took a lot of time for the previous question.
Sure, I can go. I think this is a debate which has been on for several years now. It isn't something new, and I think the only reason it's not being implemented according to the law minister as well is that different factions are not coming into agreement for it. Principally, it seems to be a logical idea that you have one capital to recruit judges, and then as it is the transferable job within district to district right now as well. Here you get the ability to try to start from one high court and then probably learn through that and move on to another high court, probably use your learnings from there and implement it somewhere else. You can do cross-judicial training as well across different high courts and try to even address systematic issues on a more holistic level if you do it as an all-India sort of process. There can also be more centralized training because then everybody is under the same umbrella and coming in through the same umbrella as well. So I think there are a lot of merits to it. The only question is of having any factions kind of accept the recommendation.
Yeah, may I also add to what Raveena just said? Look, it's again a question of supremacy and question of insecurity. Civil servants, if we talk about IS and IPS in the domestic spectrum, I'm not talking about IFS, foreign services, I'm talking about IS and IPS. There has been massive debate going on that the judicial services should be also treated as premium or premier civil services. It can be called judicial services, but they should be treated at par with IAS and IPS, perhaps even more than IS. But they are not. I have seen myself, and I've experienced it at district level. The junior judiciary, the lower judiciary, is subordinate to the deputy commissioner, is by and large subordinate even to the superintendent of police, who's an IPS officer. The judges, the sub-judges, the magistrates look up to deputy commissioner or the IPS officer in charge there, who's of the same age group or perhaps younger to them, as a superior class. And I have seen many a times deputy commissioner calling the judges to his residence to get some report and so on and so forth, because subordinate judiciary is treated as a state service. Either they are controlled by the government in power at the state, or if we are talking about additional district judges, they are controlled by the High Court. But whatever it be, they are actually controlled by the state machinery. Whereas when you talk about IS and IPS, no matter, they might be reporting to the state establishment, but their services are controlled by the center. So eventually, I think somewhere there is a debate about losing out control, about federalism, our constitution, whether it, because is not a unitary system, it's a mix of unitary federal system. So states don't want to give up the judiciary, basically. But I feel that if that happens, it's going to be the biggest reform, and it will give a great lift to judicial reforms, which we have been anticipating, and it will improve our judiciary multiple times. For instance, Ridhi or Raveena, becoming judges, and though they're much better off today, but assuming that they were to become judges, they might have been appointed in Delhi, but they would be posted, let's say, in Mumbai, or let's say after 3 years in Bangalore. So they are carrying their experience from one city to another, and then they are also becoming all the more impartial. Nobody can approach them because they don't belong to that place. So the people will not like to unnecessarily, influence them or somehow try to put some pressure, etc. So it will be very good for the independence of judiciary as well, if it becomes an all India service.
And I definitely agree. I feel like the question raises some interesting points on Indian judiciaries and the entire concept of separation of powers and a federalist structure, as Hemant sir pointed out, and what distinguishes a civil servant, IS officer, from a judicial officer, in such that a centralized exam can happen for the former but not for the latter. I mean, while this is a tussle that the center and state will not, like, either party will not let go of, because the latter does not want to lose out on its control that it has in appointment of judges and the selection process. There are merits to a centralized appointment system and a centralized examination, like that has been suggested, the AIGS. I feel like in a country, the cons and what the state's argument has structured around in sort of suggesting against this introduction of a centralized system is how diverse India is, and how the adoption of languages, at least in district courts by lawyers, is still restricted to the colloquial language or the language of the state. And as we all know, language every state is different and changes every 30-20 kilometers in India. So, but while those considerations do exist, they remain the same for a civil servant and for an IPS officer or for an administrative officer. So I feel like these considerations are being leveled as center considerations, but I feel like definitely can be worked out because the idea in principle and in practice could definitely be great and will go a long way in reducing pendency of cases and backlog of cases, which is entirely what our panel is discussing about today. So,
Exactly. Thank you so much, sir. You are not audible to us.
I said somebody just sent me this link. I think this is on Facebook Live. We guys are on Facebook Live as well.
Yes, sir. We are on Facebook Live as well as YouTube.
Yeah. This is a Facebook. Somebody just sent me. I was reading it.
Yes.
Good
So
reach.
the next
Good reach you have. I think it's nice, well organized. Yeah.
Thank you, sir. Thank you, sir. So the next question in the chat box which we have is, to what extent do you think that the judicial reforms take into account the plight of the non-human persons or animals in particular? What changes do you suggest in light of overall reforms? If Raveena ma'am could take this question up.
Can you repeat the question?
Ma'am, the question is, to what extent do you think have the judicial reforms taken into account the plight of non-human persons, animals in particular, and what changes do you suggest in light of the overall reforms?
I think there isn't much. We have one poor Manika Gandhi who tries her level best, but there isn't much that's being done, and this is a pressing concern. But I think reforms on this end are more required on an administrative side rather than judicial side. One, two, if you look at it from the judicial side, I think we should have a cell within the National Legal Services Authority and respective state legal services authorities that deal with cases regarding animal cruelty and violence. And I think whenever someone lodges a complaint at any of these regional offices, or if they have a website or centralized portal for complaints, one of the judicial officers from these, NALSA or respective state legal services authority should take it up and look into it very strictly. At the same time, as I said, administratively, this requires the most amount of work. So police, especially in any area, or local guards in an area, they need to be most vigilant to ensure that people treat animals with respect as well, and they don't take their frustration out on them. I mean, they're also living beings, and that's not fair at all, and it's inhuman behavior. So, penalizing them is one thing, but before that, we must try to avoid it and make it strict enough that they don't even attempt. So, that's my opinion on it.
Thank you, ma'am, for sharing your views. So we have this third question from our attendee, Vasundhara. She says that she was working on a project on custodial rape. And I want to add on that even I was working on a project on condition of women in prisons. And I found out that Law Commission has also released its report on the same, and they had pointed out certain things, and they recommended several things to be incorporated in the existing laws, but as of now several things aren't yet enacted and implemented. So keeping an eye on the existing laws, we can see that they are not good enough when it comes to custodial rape and the plight of women in prison. So what's the view of our panelists on this? Do we think that we have a lack of laws in this regard or not?
So I'll take the lead on this, but I'll preface it by saying that unfortunately I have very limited experience and expertise on custodial rape laws in India and their practice thereof. The plague that is custodial rape is a menace in society, and there have been several law commission reports, PUDR reports, and on torture, rape, and the general mental health depraved conditions of rape survivors in prisons languishing in India. And I believe the Law Commission reports, while beneficial in some limited extent on general cases, has a lot of drawbacks, and it's especially in on this front. One of the recommendations that I believe, if memory serves me correctly, it was, I think, and I would need Nupur to corroborate me on this, was the Law Commission report, I think, introduced in 2013 on, or
Yes,
was that
around that.
Correct. So, I believe, like, studying that in law school, my limited interaction with this field has been in law school entirely. There was a novel concept of gender neutrality in that was introduced in custodial rapes, and I believe that custodial rapes is also definitely distinguishable from uh, rape and sexual assault that is prevalent in society, where we see the survivors being generally women. Men are certainly not excluded, but the reverse of that is seen in prisons and in custodial rapes. So definitely the gender neutral language that the Law Commission report introduced was a novel step in that direction. I again, I would like to just emphasize that I have very little experience in that, and that appreciate any help or corroboration from my panelists on this front.
I also have very limited experience on this, but I think rules need to be made stricter. This is still a phenomena that continues, and I think we've seen bad cases like Ramiza B. Matra, and it just continues. And these are at least 40 years before us, but the number of cases hasn't reduced. Maybe the people with strength to report it has, and we need to ensure that this happens lesser and lesser. While police stations today or places of custody have cameras and there is a process to record what's happening, the footage is often not available when required. Because we need to understand that the people who look into these things are also the people committing the crimes in these cases. So we need to be very cognizant when we think of reforms in this area.
All right. Thank you, Raveena ma'am. Thank you, Ridhi ma'am. Now, seeing the time of our event, I think this could be the last question from our attendees. And this question is for Hemant sir. This question is by Dr. Surendra Singh Chundawat. And he writes that, Hemant sir, regarding ADR, why did retired Justice N.V. Ramana stress more upon the conciliatory mediation and less on the other forms of ADR?
Well, it's very clear that arbitration, because when you talk about ADR, the first methodology for resolution of dispute alternatively, which comes to our mind, is arbitration. And I'm telling you that as the arbitration process has unfolded in last 2 decades, it has become delayed and it has become highly expensive for the litigants. Today, when we talk about arbitrations, or we read about arbitrations, or we hear about arbitrations, it is only about corporate heavy-duty arbitrations. Have you ever heard about arbitration of common men or small traders or shopkeepers or medium or micro level industrial sort of parties or businesses, and so on and so forth? Because it is unaffordable. Because when you are opting for a particular platform or forum, you have to pay a huge amount to that platform or the association, assuming, even if that is symbolic, the lawyers who are engaged, they charge you fee, and then you have to pay fee to the arbitrator. And invariably, you have 3 arbitrators, one obviously umpire or referee, whatever you may call, because one arbitrator each appointed by the parties, and then these 2 appoint a 3rd arbitrator. And these arbitrators, really, you have to pay them exorbitant fee. So eventually, arbitration has turned out to be a very expensive process and very painful as litigation. So the historically, it has not proved to be of any benefit. Now, mediation, conciliatory mediation, why it is looked at as the most phenomenal and conducive and acceptable option under ADR is, for I would say there are multiple reasons, but predominantly one is that there is an element of expertise which is involved in bringing about 2 parties to a discussion level, and very scientifically moving towards a system of acceptability where you expect both the parties to take one step forward. So this is not only legal counseling, it is also psychological counseling. Not every lawyer can become a good mediator, because there is a mix of psychology and law in mediation. And that is first part, that predominantly, there is somebody who's acting like a counselor and getting both the parties to at least a talking point. Second good point is that there is only one party which is to be paid, which is the mediator. And invariably, we have seen that the mediation fee scales have not climbed up much. They are mediation is looked at as a very noble kind of profession. People think that they are doing some constructive activity. So, I mean, best of the senior advocate, designated senior advocates I have seen being appointed as mediators, charging very nominal fee, because they start living the aspirations of the party. They start living the points of dispute, and they sympathize. They don't hold any contempt vis-a-vis the parties, either of the parties. So by nomenclature, mediation is being labeled and branded as a very noble profession, a profession which is more like a not-for-profit activity. So it has become obviously less expensive. Third is that it does not come with any baggage of obligations, which means that you might spend 15 days, 1 month, 2 months, or 3 days trying to achieve conciliation. And if you fail, there is no verdict coming. You are back to square one, and none of what you have shared with the mediator becomes part of any of the legal proceedings in the future. These are in camera, privy, privileged, confidential proceedings. And on day one, both the parties sign that these proceedings, whether verbal or written, will never ever in future form part of any set of legal proceedings if the parties choose to contest the matter. And once they arrive, assuming if they arrive at a settlement, then I mean it is such a simplified process. You just enter into a few page agreement, and that agreement can be registered. That agreement, if you want, can be even converted into a decree, but it may not. There is no obligation per se. So mediation obviously comes with several sets of advantages if one was to compare it in the same family of ADR. In the same family of ADR, where predominantly there is arbitration and mediation then could have some other sub families, but predominantly mediation has become hot favorite of everybody, and arbitration, I'm telling you, is on way out, or perhaps it is meant only for big wigs now, because when top companies enter into joint ventures, and I don't want to name those big companies, but you can just Google and you'll find that arbitration, if we talk about arbitration, we talk about some top fortune companies today, and if at all some arbitration are happening at smaller level, they are happening through mercantile companies, through associations like WICCI, SOCHAM, CI, etc. They provide some little platform, but to my knowledge, arbitration is not achieving great results. And plus, we have seen in the case of Amazon what happened. An award given in Singapore was thrashed left, right, and center in Delhi High Court, then it went to Supreme Court. So there is no finality. Nobody has ever has given any respect or seriousness to the award, whereas awards are supposed to be finality, and they can be challenged only on very limited grounds. But every court is interfering with the awards, be it High Court or be it Supreme Court. So despite spending a lot of money and shortcutting the whole process of dispensation, you still land up in courts challenging the awards. So what do you gain out of it? Nothing. So I feel that's the backdrop of why mediation has gained so much of momentum.
Exactly, sir. Thank you so much for your insights, and thank you, everyone. With this, we are moving close to the end of our time together. I take this moment to ask our panel members to share this one thing that they would like this audience to take away from the session. And let us start with him, sir.
Well, I mean, I would say that, the only thought which comes to my mind is what Mahatma Gandhi said, that if you want to bring a change, be the change. And I'm really sort of so much encouraged and thrilled by seeing my young panelists who are by and large age of my own children, and I definitely feel that, I mean, these youngsters are the change makers. And to all the audiences here, participants, I think that if given the opportunity, you should get email IDs of Raveena and Ridhi, and get some little mentorship from them, and never ever think that that there can be no learning from people with no gray hair. They may not have gray hair as I have, but they have spent so much time, and I feel that even when they were studying, that is also not studying, that was an experience. So I mean, added that, they are experienced people, and they have done so well for themselves, and you should take inspiration from youngsters more than the seniors, and try to become the change makers in the society. Don't sit like ducks. Whatever little thing you can do, you can help your neighbor, you can help that guy who puts a cart in front of your house. I'm telling you, the sense of accomplishment you will get by helping those in need is outstanding, which I'm telling you from experience, that no much has given me that much pleasure what I have achieved by helping the poor and needy, in terms of not money, in terms of counseling.
Thank you so much, sir, for quoting such a beautiful saying. And for sure, we, Tanishka, and everyone from our council will learn a lot, not only from Raveena ma'am or Ridhi ma'am, but also from you, sir. Moving further, Raveena ma'am, could you please share your opinion?
Firstly, thank you for the very, very kind words, Hemant sir. I hope we are deserving enough of that praise. But the only, I think, takeaway that I feel people should go back and reflect on is that we've spoken about so much reform, and we've spoken about different avenues in which that can be made. However, as sir pointed out, it won't happen if we merely talk and don't do. So in your own small way, do reflect and think about how you can be part of the change and the process. And nothing is ever too small. It could be helping someone out, it could be having someone giving some pro bono advice. It could even be something which I think every person who's a law student or a fresh professional should do, is signing up for your state legal services authority. Please look up your respective state legal services authority and sign up, to be there to help them, be an advocate for them, and take on some pro bono cases if you can in the years to come. I think that would be a huge change, and lead to greater impact. So thank you so much for having me.
Sure, ma'am. We'll take all these points in consideration. Now, let's hear it from Ridhi, ma'am.
Thank you so much, Hemant sir, for these very kind words. I'm not entirely sure if I'm deserving of that. I'm very sure Raveena is, seeing the tremendous body of already behind her. And just to sort of complement to that, wherever I am or my colleagues and friends are, it's due to the wealth of expertise and advice that has been passed on to us by learned professionals such as Hemant sir. And so we'll never be any less grateful for that. Just as on a parting thought, I have my program, my master's program in HLS. I think in the short 1 month that I've been here, I've really sort of understood the value of our judiciary system and the Indian legal system on its own. Because when you're sort of constrained in your own sort of state or in your country, you're sort of bound to think that, oh, कुछ नहीं हो सकता, यहाँ पे तो कुछ नहीं हो सकता, यहाँ तो ऐसे ही चलता है, and this doesn't work, and that Indian legal system is so fraught with so many problems, and this happens, and judicial delays and backlog of cases, and reforms are not adequately being addressed, or if they're addressed, they're not being implemented properly. And this is far or less the story of every country. Every country is fraught with its own peculiar problems and problems of demographics and just administration of justice. And India, with a very nascent history of, I still believe, very nascent history of independence, has come a long way. So I feel like as Indians, we should be definitely proud of that, and we should take pride in how far and how quickly our legal system has adapted to change and has adapted to international normative standards of administration of justice. That pride also shouldn't be taken so far as to mean ego. And there is a long way that we still have to go, and there are miles to go before we sleep. And I feel like talks like these, discussions like these, the fact that uh, it is a topic of discussion now. What is the need for judicial reforms? We have so many young attendees in this chat. Like I saw some like 98 or 100 people. It's a great momentum that we must, like it has, if it started, it should definitely be kept going, to sort of reflect on how far we've come and how far we have to go, to understand the differences that our legal system has from other countries, to not sort of want to mimic a US judicial system, a UK judicial system, to sort of also understand that they are the way that they are because of their checkered histories of independence, of at least colonizing in the latter part. So to not want to not sort of wanting to ape any judicial or legal system, but wanting to sort of create, or in our case strengthen, our existing one, is also an idea that we should reflect on, in addition to definitely what has been pointed out by Raveena and Hemant sir. There is pro bono advocacy services, and definitely what the most enriching part of my very limited legal professional career has been uh, the sort of pro bono advocacy that I've been fortunate enough to do for displaced communities in India. And that kind of sort of enrichment you can only uh, get from helping marginalized communities, or marginalized persons, and impoverished groups from our society. And in India, the opportunity to do that for is tremendous. So definitely engage in that. As young students of law, as professionals of law, we should definitely be encouraged to look towards those avenues as well. So that is also a parting thought that I would like to end my thing on.
Thank you so much, ma'am. I mean, we all agree with this point that we all could bring a change if we keep on getting the constant guidance and support from the esteemed panelists, like three of you. And with this, we have come to the end of our today's panel discussion. To no surprise, this had been an extremely judicious discussion, which has given a number of insightful points to take away, be it the great potential in the reformation of judiciary as highlighted by Hemant sir, or the use of artificial intelligence as said by Ridhi ma'am, or the more concise judgments following the IRAC format as said by Raveena ma'am. A powerful independent judiciary is of great importance for India's development. The very core of the society is an autonomous and unbiased judiciary and a swift and effective operation of the same. The propagation of judiciary in our society is heavily dependent on the judicial system. Hence, its credibility is central to the sustainability of India's civil order. As long as Indian citizens believe in court mechanisms and integrity, the judiciary remains the interpreter of the law and determinant of the social justice as it should be. Sadly, some things restrict the application of our laws to all Indian people. Many who challenge courts not only pay the burden of the case, but they also waste a great deal of time waiting. For a long time in India, there have been disputes regarding the system of judiciary. Judiciary is considered as one of the most important pillars in the framework. The 70 years of judicial system has reformed itself in many ways. And irrespective of these reforms, there is still a lot of development that has to be made, probably. The most important thing to humanity is an efficient and effective judicial system.
With this, we have come to the end of our discussion for the day. I would like to extend our heartfelt gratitude to the respected and esteemed panelists for sparing time from their busy schedule and enlightening us with their valuable words and experiences. We can deny that today's panel discussion has given us a lot of valuable insights. I would like to thank the President of National Judicial Reforms Council, Ms. Aishwarya Bhatia, and Vice President, Ms. Devanshi Parasar, for making this event happen. I want to thank the council members who really worked hard for making this event a successful one. Last but not the least, a huge thanks to all the attendees who stayed with us throughout the discussion and kept it active with their queries, doubts, and concerns. Thank you, everyone, and have a good day.